memorandum of law on the name. Many people are involved in diligent research concerning the use of the all-capital letter for proper names, ergo John Paul Jones, all-capital letters, as a substitute for John Paul Jones, uppercase, lowercase, in proper form. In all court documents, driver's license, bank accounts, birth certificates, etc., is the use of all capital letters to designate a name some special English grammar rule or style? Is it a contemporary American style of English? Is the use of this form of capitalization recognized by educational authorities? Is this an official, judicial, or U.S. government rule and or style of grammar? Why do attorneys, court clerks, prosecutors, judges, insurance companies, banks, credit card companies, utility companies, etc. always use all capital letters when writing a proper name? What English grammar experts say, one of the foremost authorities on American English grammar style, composition, and rule is the Chicago Styles Manual, or the Chicago Manual of Style. The latest 14th edition, published by the University of Chicago Press, is internationally known and respected as a major contribution to maintaining and improving the standards of writing or printed text. Since we can find no reference in their manual concerning the use of all capital letters with a proper name or any other usage, we wrote to the editors and asked this question: is it acceptable, or is there any rule of English grammar to allow a proper name to be written in all capital letters? For example, if my name was John Paul Jones, uppercase, lowercase, can it be written as all capital letter John Paul Jones? Is there any rule covering this? The editorial staff of the University of Chicago answered, writing names in all caps is not conventional. It is not Chicago style to put anything in all caps. For instance, even if Gone with the Wind, all capital letters, appears on the title page, all in caps, we would properly render it Gone with the Wind. We would properly render it Gone with the Wind in a bibliography. The only reason we can think of to do so is if you are quoting some material where it is important to the narrative to preserve the casing of the letters. We are not sure in what context you would like your proper name to appear in all caps, but it is likely to be seen as a bit odd. Law is extremely precise. Every letter, capitalization, punctuation, mark, etc. in a legal document is utilized for a specific reason and has legal, i.e. deadly force, consequences. If, for instance, one attempts to file articles of incorporation in the office of the Secretary of State of a state, if the exact title of the corporation, down to every jot and title, is not exactly the same each and every time the corporation is referenced in the document to be filed, the Secretary of State will refuse to file the papers. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation identifies an entirely different legal person. It is therefore an eminently valid and possibly crucial question as to why governments, governmental courts, and agencies purporting to exist in some undefined, unapproved manner within the jurisdiction of this state insist on always capitalizing every letter in a proper name. Mary Newton Brunder, Ph.D., also known as the Grammar Lady, who established the Grammar Hotline in the late 1980s for the Coalition of Adult Literacy, was asked the following question: why do federal and state government agencies and departments, judicial and administrative courts, insurance companies, etc. spell a person's proper name in all capital letters? For example, If my name is John Paul Jones, uppercase, lowercase, in proper form, is it proper at any time to write my name as John Paul Jones, all capital letters? Dr. Burden's reply was short and to the point. It must be some kind of internal style. There is no grammar rule about it. It seemed that these particular grammatical experts had no idea why proper names were written in all caps, so we began to assemble an extensive collection of reference books authored by various publishers, governments, and legal authorities to find the answer. What English grammar reference books say. Manual on Usage and Style. One of the reference books obtained was the Manual on Usage and Style, 8th edition, ISBN I87867451X, published by the Texas Law Review in 1995. Second D, Capitalization, paragraph D, 1:1 states, always capitalize proper nouns. Proper nouns, independent of the context in which they are used, refer to specific persons, places, or things. Ergo, Dan, Austin, Rolls-Royce. Paragraph D, 3:2 of section D states, capitalize people, state, and anything and any other terms used to refer to the government as a litigant. Ergo, the people's case, the state's argument, but do not capitalize other words used to refer to litigants. Ergo, the plaintiff, defendant, mason. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual that purports to pertain to them, or the act is a deliberate violation of the rules for undisclosed reasons. In either ignorance of the law is no excuse, or violation, one violating the law he enforces on others is acting under title of nobility and abrogating the principle of equity, of equality under the law. Of law, they continue to write. Plaintiff, defendant. The state of Texas is in all capital letters, and proper names of parties in all capital letters on every court document. The Elements of Style. Another well-recognized reference book is The Elements of Style, 4th edition, ISBN 0205-30902-X, written by William Strunk, Jr. and E.B. White, published by Allen and Bacon in 1999. Within this renowned English grammar and style reference book is found only one reference to capitalization located within the glossary at proper noun, page 94, where it states, the name of a particular person, Frank Scimitar, place, Boston, or thing, Moby Dick, proper nouns are capitalized. There's an obvious and legally evident difference between capitalizing the first letter of the proper name as compared to capitalizing every letter used to portray the name. The American Heritage Book of English Usage. The American Heritage Book of English Usage, a particular and authoritative guide to contemporary English, published in 1996 at Chapter 9, Email, Convention and Kirk's Informality, states, to give a message special emphasis, an emailer may write entirely in all capital letters, a device emailers refer to as screaming. Some of these visual conventions have emerged as a way of getting around the constraints on data transmission that now limits many networks. Here is a reference source within contemporary modern English that states it is of an informal manner to write every word of, specifically, an electronic message, aka email, in capital letters. They say it's screaming to do so. By standard definition, we presume that this is the same as shouting or yelling. Are all judges, as well as their court clerks and attorneys, shouting at us when they corrupt our proper names in this manner? If so, what happens to the decorum of a court if everyone is yelling? Is the insurance company screaming at us for paying the increased premiums on our policy? This is doubtful as to any standard generalization, even though specific individuals insistence may indicate this to be true. It is safe to conclude, however, that it would also be informal to write a proper name in the same way. Does this also imply that those in the legal profession are writing our Christian names informally on court documents? Are not attorneys and the court's supposed to be specific, formally writing all legal documents to the letter of the law? If the law is at once both precise and not precise, what is its significance, credibility, and force and effect? New Oxford Dictionary of English. The New Oxford Dictionary of English is published by the Oxford University Press. Besides being considered the foremost authority on the British English language, this dictionary is also designed to reflect the way language is used today through example sentences and phrases. We submit the following definitions from the 1998 edition. Proper noun, also proper name. Noun, a name used for an individual, person, place, organization, spelled with an initial capital letter, ergo Jane, London, and Oxfam. Name, noun, 1a, a word or set of words by which a person, animal, place, or thing is known, addressed, or referred to. My name is Parson, spelled proper, uppercase, lowercase. John Parson is the German name for lime water. Verb 2, identify by name, give the correct name for. The dead man has been named as John McIntosh. Phrase 3, in the name of, bearing or using the name or a specified person or organization. A driver's license in the name of William Saunders. From the Newberry House Dictionary of American English, published by Monroe Allen, publisher in 1999, name, noun, a word by which a person, place, or thing is known. Her name is Diane, or Daniel, both with upper, lowercase, in proper grammatical form. We can find absolutely no example in any recognized reference book that specifies or allows the use of an all capital letters name, proper or common. There is no doubt that a proper name, to be a grammatically correct, must be written with only the first letter capitalized, with the remainder of the word in a name spelled with lowercase letters. U.S. Government Styles Manual. Is the spelling and usage of a proper name defined officially by U.S. government? Yes. The United States Government Printing Office, in the Style Manual, March 1984 edition, the most recent edition published as of March 2000, provides comprehensive grammar, style, and usage for all government publications, including court and legal writings. Chapter 3, Capitalization, at subsection 3.2, prescribes rules for proper names. Proper names are capitalized. Examples given are Rome, Brussels, John Macadam family, Italy, and Anglo-Saxon. At Chapter 17, Court Work, the rules of capitalization as mentioned in Chapter 3 are further reiterated. 17.1, court work differs in style from other works only as set forth in this section. Otherwise, the style prescribed in the preceding section will be followed. After reading subsection 17 in entirety, I found no other reference that would change the grammatical rules and style specified in Chapter 3 pertaining to capitalization. At subsection 17.9, the same official U.S. government manual states, in the titles of cases, the first letter of all principal words are capitalized, but not such terms as defendant and appellee. This little bastard here, come here. God's wonderful creatures. Okay. In the title of case, the first letter of the principal words are capitalized, but no such term as defendant and appellee. This wholly agrees with the Texas Law Review Manual on usage and style as referenced above. Examples shown in subsection 17.12 or 17.12 are also consistent with the aforementioned subsection 17.9 specification, that is, all proper names are to be spelled with capital first letter, the balance of each spelled with lowercase letters. Grammar, punctuation, and capitalization. The National Aeronautic and Space Administration, NASA, NASA, has published one of the most conscious U.S. government resources on capitalization. NASA's publication, SP 7084, Grammar, Punctuation, and Capitalization, a handbook for technical writers and editors, was compiled and written by the NASA Langley Research Center in Hampton, Virginia. Chapter 4, Capitalization, they state in 4.1 introduction. First, we should define terms used when discussing capitalization. All caps means that every letter in the expression is capitalized like this, all capital letters. Caps and IC means that the principal words of an expression are capitalized like this. Caps and small caps refer to a particular font or type containing small capital letters instead of lowercase letters. Elements in a document, such as the headings, titles, and captions, may be capitalized in either sentence style or headline style. Sentence style calls for capitalizations on the first letter and proper nouns, of course. Headline style calls for capitalization of all principal words, also called caps and IC. Modern publishers tend toward a down style of capitalization, that is, towards use of fewer capitals rather than an up style. Here we see that in headlines, titles, captions, and in sentences, there is no authority usage of the all caps. At 4.4.1, capitalization with acronyms, we find the first authoritative use for the all caps. Acronyms are always formed with capital letters. Acronyms are often coined for a particular program or study and therefore require definition. The letters of the acronym are not capitalized in the definition unless the acronym stands for a proper name. Wrong. The best electronic publishing system combined, what you see is what you get. WYSIWYG features. Correct. The best electronic publishing system combined with you see is what you get. WYSIWYG futures. But Langley is involved with the National Aerospace Plane NASP program. This cites, by example, that using all caps is allowed in an acronym. Acronyms are words formed from the initial letters of successive parts of a term. They never contain periods and are often not standard. So, that definition is required. Could this apply to lawful proper Christian names? If that were true, then John Smith, the all capital letter name, would have to follow a definition of some sort, which it does not. For example, only if John Smith, the all capital letter name, were defined as John Orley Holistic Nutrition of the Smith Medical Institution to Holistic John Smith, the all capital letter names, would this apply? The most significant section appears at 4.5, Administrative Names. Official designation of political division and of other organized bodies are capitalized. Names of political divisions: Canada, New York State, United States, Northwest Territory, Virgin Islands, Ontario Province. Names of governmental units: U.S. Government Executive Departments, U.S. Congress, U.S. Army, U.S. Navy. In all of those that I just mentioned, the first letter in each proper noun is identified with a capital letter because it's a person, place, or thing. Review's Manual on Usage and Style. The usage of the legal fiction, the real life dictionary of the law. The author of the Real Life Dictionary of Law, Gerald and Kathleen Hill, are accomplished scholars and writers. Gerald Hill is an experienced attorney, judge, and law instructor. Here is how the term legal fiction is described. Legal fiction, noun: a presumption of a fact assumed by a court for convenience, consistency, or to achieve justice. There is an old adage: fictions arise from the law and not law from the fiction. Oren's Dictionary of the Law. From Orrin's Dictionary of the Law, published by the West Group, 1999, within the definition of fiction is found. A legal fiction is an assumption that something that is or may be false or non-existent is true or real. Legal fictions are assumed or invented to help do justice. For example, bringing a lawsuit to throw a non-existent John Doe off your property used to be the only way to establish a clear right to the property when legal title was uncertain. Merriam-Webster's Dictionary of Law. Merriam-Webster's Dictionary of Law, 1996, states, legal fiction, something assumed in law to be fact, irrespective of the truth or accuracy of that assumption. Example, the legal fiction that a day has no fraction. Fields versus Fairbanks, North Star Borough, 818, page 2D, 658, 1991. This is the reason behind the use of the all caps when writing a proper name. The U.S. and state governments are deliberately using a legal fiction to address the lawful, real, flesh and blood man or woman. We say this is deliberate because their own official publications state that proper names are not to be written in all caps. They are deliberately not following their own recognized authorities. In the same respect, by identifying their own government entity in all caps, they are legally stating that it is also intended to be a legal fiction. As stated by Dr. Mary Newton Burden in the beginning of this memorandum. The use of all caps for writing a proper name is an internal style for what is apparently a predetermined usage and, at this point, unknown jurisdiction. The main key to the legal fiction is assumption, as noted in each definition above. Conclusion. There are no official or unofficial English grammar styles manual or reference publications that recognize the use of the all caps when writing a proper name. To do so is by fiat, within and out of an undisclosed jurisdiction by unknown people who unrevealed seasons by juristic license of arbitrary presumption not based on fact. The author of the process unilaterally create legal fictions for their own reasons and set about to get us to take the bait, fall for the deceit. Assumption of a legal fiction. An important issue concerning this entire matter is whether or not a proper name perverted into an all caps assemblage of letters can be substituted for a lawful Christian name or any proper name, such as the state of Florida. Is the assertion of the all capital letter name or names legal? If so, from where does this practice originate and what enforces it? I believe that was established by Justinian in like 524 AD. A legal fiction may be employed when the name of the person is not known, and therefore using the fiction name John Doe as a tentative or interim artifice to surmount the absence of true knowledge until the true name is known. Upon discovering the identity of the fictitious name, the true name replaces it. In all cases, a legal fiction is an assumption of purported fact without having shown the fact to be true or valid. It is an acceptance with no proof. Simply to assume is to pretend. Orrin's Dictionary of Law says that the word assume means to take upon or take responsibility for, to receive, to undertake, see assumption, to pretend, to accept without proof. These same basic definitions are used by nearly all of the modern law dictionaries. It should be noted that there is a difference between the meaning of the second and third definition with that of the first. Pretending and accepting without proof are of the same understanding and meaning. However, to take responsibility for and receive or assumption does not have the same meaning. Orrin's defines assumption as formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually involves taking over the seller's mortgage debt when buying a property, often a house. Now, what happens if all the meanings for the words assume are combined? In a literal and definitive sense, the meaning of assume would be the pretend acceptance without proof that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all this in defining a legal fiction, the use of a legal fiction is an assumption or pretension that the legal fiction named has received and is responsible for a debt of some sort. Use of the legal fiction, John P. Jones, all capital letters, in place of the proper name, John Paul Jones, uppercase, lowercase, implies an assumed debt guarantee without any offer of proof. The danger behind this is that if such an unapproved assumption is made, unless the assumption is proven wrong, it is considered valid. An assumed debt is valid unless proven otherwise. An unrebutted affidavit, claim, or charge stands as the truth in commerce. This is in accord with the Uniform Commercial Code, valid in every state and made a part of the statutes of each state. A name written in all caps resembling a proper name but grammatically not a proper name is being held as a debtor for an assumed debt. Did the parties to the complaint incur that debt? If so, how and when? Where is the contract of indebtedness that was signed and the proof of default thereon? What happens if the proper name, ergo, John Paul Jones, uppercase, lowercase, answers for or assumes the fabricated name, i.e. John P. Jones, all capital letters? The two become one and the same. This is the crux for the use of the all caps name by the U.S. government and the state. It is the way that they can bring someone into the de facto venue and jurisdiction that they have created, by implication of definition. This also is for the purpose of some manner of assumed debt. Why won't they use the state of Texas or John Doe, uppercase, lowercase, in their courts or on a driver's license? What stops them from doing this? Obviously, there's a reason for using the all caps name, since they are very capable of writing proper names, just as their own official styles manual states. The reason behind legal fiction is found within the definition as cited above. The legalities of the all capital letter names. We could go on for hundreds of pages citing the legal basis behind the creation and use of the all capital letters names. In a nutshell, fabricated legal persons, such as State of Texas all capital letter name, can be used to fabricate additional legal persons. Fictions arise from the law, not law from the fiction. Bastard legal persons originated from any judicial government actor that wishes to create them, regardless of whether he, she, it is empowered by law to do so. However, a law can never originate from a fictional foundation that doesn't exist. The generic and original U.S. Constitution was validated by treaty between individual nation states, all of which are artificial corporate entities, since they exist in abstract idea and construction only. Contained within it is the required due process of law for all the participating nation states of that treaty. Representatives of the people in each nation state agreed upon and signed it. The federal government is not only created by it, but is also bound to operate within its guidelines of the constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the organic U.S. Constitution. Was it created accordingly to the lawful process or created outside of lawful process? Executive orders and directives. For years, many have researched the lawful basis for creating all caps juristic persons and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from constitutional due process? There's a very simple answer to the creation of such purported laws that are really not laws at all: executive orders and directives. They are color of law. Without being valid laws of due process, these executive orders and directives have the appearance of law and look as if they are laws, but according to due process, they are not laws at all. Rather, they are laws based on fictional beginnings, and are the inherently defective basis for additional fictional laws and other legal fictions. They are regulated and promulgated by administrative codes, rules, and procedures, not due process. Currently, executive orders are enforced through a charade known as the Federal Administrative Procedures Act. Each state has also adopted the same fatally flawed administrative laws. Lincoln established executive orders 85 years after the end of... Stop calling me. I'm in the middle of something, and I know damn good and well you can see that I'm in the middle of something. Don't call me. That's rude. 85 years after the independence of the United States, 7 southern nation states of America walked out of the second session of the 36th Congress on March 27, 1861. In so doing, the constitutional due process quorum necessary for Congress to vote was lost, and Congress was adjourned sine die, or without day to reconvene. This meant that there was no lawful quorum to set a specific day and time to reconvene, which, according to Robert's Rules of Order, dissolved Congress. This dissolution automatically took place because there are no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the state. Lincoln's second executive order on April 1861 called Congress back into session. Now, that was really a memorandum of law that he did, telling Congress they needed to come back because he felt there was something important that needed to be discussed at that moment in time. Now, it's important to realize that many people didn't show up to that, but enough people congregated that they considered Congress reconvening. Later, but not under the lawful authority or lawful due process of the Constitution, solely in his capacity as Commander-in-Chief. Solely in his capacity of Commander-in-Chief. Not President of the United States of America, but Commander-in-Chief of the largest standing military force in the world, of the U.S. military. Lincoln called Congress into session under authority of martial law. Since April of 1861, remember, he did the declaration of war, but he never did the proclamation to end it. And because he never did the proclamation to end it, we've always been in a perpetual state of national emergency. We've always been at war. Congress has not met based on lawful due process. The current Congress is legal fiction based on nothing more meritorious than, yeah. So, what are you going to do about it? Having a monopoly on the currency, law, and what passes for government, and most of the world's firepower, the motto of the powers that be is, we have got what it takes to take what you've got. Legal fictions laws, such as the Reconstruction Act and the implementation of the Lieber Code, were instituted by Lincoln soon after and became the basis for the current laws in the U.S. Every purported act in effect today is de facto based on colorable fictitious entities created arbitrarily out of nothing without verification, lawful foundation, or lawful due process. All of such laws are not law, but rules or rulership by force and conquest, originating from and existing in military martial law jurisdiction, jurisdiction of war, wins, losses, interactions consisting of eating or being eaten, living or dying, food chain, law of necessity, suspension of all law other than complete freedom to act in any manner to eat, kill, or destroy, or avoid being eaten, killed, or destroyed. No law, lawlessness, complete absence of the lawful basis to create any valid law. So like I told you before, if you've been following me for a few years, the United States, for all intents and purposes, there are no laws. It's lawless because contract creates the law and equity follows the law, which means that no man is excused of the law, for all men are responsible for knowing the law because they're all responsible for knowing the contracts they enter into. Bingo, bango, period. That's the way it is. All right? So the United States, for all intents and purposes, is lawless. Contractually being a victim of those acting on the alleged authority granted by the law of necessity. Now, remember how I always tell you, necessity trumps law. If I need to go get some provisions or first aid kit or whatever, I don't care if I got a driver's license. If I've got an automobile, the keys are in the ignition, I'm using it to go get those provisions out of necessity. And necessity trumps any of their colorable statutes, codes, city ordinances, rules, and regulations that they presume and assume to be law. Okay? I can execute it with impunity. No lawful objections, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence. No bona fide enforceable contracts, no valid enforceable nexus, absolute right to engage in any action of any kind in self-defense, complete and total right to disregard any alleged jurisdiction and demand from admitted outlaws committing naked criminal aggression without any credibility, and right to demand allegiances and compliance from anyone. Every president of the United States since Lincoln has functioned by executive orders issued from a military martial law jurisdiction, with the only law being the law of necessity, i.e., the war powers. The war powers are nothing new. Indeed, they have been operational from the instant the first man thought he would hide from God, tried to cheat ethical and natural law by overreaching and invade the space and territory of others, covet other people's land and property, steal the fruits of their labors, and attempt to succeed in life by win-lose games. All existing authority in the United States today derives exclusively from the war powers. Truman's reaffirmation of operational authority under the war powers begins now. Therefore, I, Harry S. Truman, all capital letters, by the way, President of the United States of America, which is really the Commander-in-Chief, acting under and by virtue of the authority vested in me by Section 5B of the Trading with the Enemy Act of October 6, 1917, 40 Stat 415, as amended Section 5B of Appendix Title 50, which is the military code. Military code is found in Title 50. And Section 4 of the Act of March 9, 1933, 48 Stat 2, Sick Transit Rights, Substance, Truth, Justice, Peace, and Freedom in America, the land of the free and the home of the brave. More like the land of the conquered and the home of the slave. The abolition of the English and American common law. Here's an interesting quote from the 1973 sessions of the U.S. Supreme Court. The American law in this country, the law in effect in all but a few states until mid-19th century, was the pre-existing English common law. It was not until after the war between the states that legislation began generally to replace the common law. Roe versus Wade, 410 U.S. 113. In effect, Lincoln's second executive order abolished the recognized English common law in America and replaced it with laws based on the fictional legal foundation, i.e. executive orders and directives executed under authority of the war powers. Most states still have a reference to the common law within their present-day statutes. For example, in Florida statutes 19999, in 1999, Title I, Chapter 2, at subsection 2.01, common law and certain statutes declared in force in state. It states, the common and statute laws of England, which are of a general and not a local nature, with the exceptions hereinafter mentioned down to the 4th day of July, 1776, are declared to be of force in this state, provided the said statutes and common law be not inconsistent with the Constitution and laws of the United States, and the acts of the legislator of this state. History 1 November 6, 1829, RS 59, GS 59, RGS 71, and CGL 87. Note that the basis of the common law is an approved act of the people of Florida by resolution of November 6, 1829, prior to Lincoln's Civil War. Also note that the subsequent laws, as a result of acts of the Florida legislature and the United States, now take priority over the common law in Florida. In April 1861, the American and English common law was abolished and replaced with legal fiction laws, aka statutes, rules, codes, based on executive orders and not the due process specified within the organic constitution. Existing and functioning under the laws of necessity ab initio, they are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. They are entirely They are entirely rules of rulership, i.e. organized piracy, privilege, plunder, and enslavement, invented and enforced by those who would rule over others by legalized violence in the complete absence of morality or moral authority, adequate knowledge, and natural law mechanisms to abolish any result other than disruption, conflict, damage, and devastation. The established maximum of the law applies. One who exercises jurisdiction out of his territory cannot be obeyed with impunity. Thanks for joining me, and thanks to all you guys who support selfgovernanceu.com and the classes that I put on. You give me the ability to do what I'm doing here today, and I just want to say thank you. And above, I'll leave the link for all the classes that I've had and a way you can donate if you choose to. Thanks for joining me, and I hope this helps you guys out.